Hello everyone, this is the lecture for Chapter 2, which is titled Courts and Alternative Dispute Resolution. Quick overview, this is going to study the American court system, both the federal court system and the state court system. We're going to focus on the state of Georgia to use for our examples in the state court discussions. And we're going to talk about the steps in litigation. Litigation, again, is fighting something out in court. Duking it out. And despite how much litigation there is today, most people's exposure to the court system is limited, and that's a good thing. Hopefully you haven't been too personally involved with the court system yourselves, but mostly it's limited to traffic court or small claims court or something like that. So also we're going to look at some alternatives to litigation and alternatives to dispute resolution aside from going the court route. That is pretty common these days, is folks trying to settle their cases without resorting to the court system and litigation because of how expensive and how time consuming and how involved that process is. So the first topic is the judiciary's role in American government. We talked in the first chapter about how the Constitution divides up the branches of government and that each branch has a check on the power of the others. The Supreme Court of the United States is not granted anywhere in the Constitution the power to determine whether or not a law is constitutional. That is a power that they brought upon themselves early on in the stages of our country. In the case of Marbury versus Madison. And in that case, the Supreme Court said, we have the power to review laws and determine if they're constitutional or not. That became known as the doctrine of judicial review. The Supreme Court just kind of invented it and wore it and has been that way ever since. Basic requirements for the justice system. The first is the idea of jurisdiction. Jurisdiction is the power of a court to hear a case. And so before a court can decide any case, it must have jurisdiction over the subject matter and the person or the persons in question. And there are two ways that it can do that. One is jurisdiction over property. If a piece of property is located in a state, then consequently the state has jurisdiction over that piece of property, and any dispute having to do with that piece of property can be brought in the state where it's located. But it's not enough for a court just to have jurisdiction over the thing or the property. Courts always have to have jurisdiction over the person, and that becomes a little more problematic. So throughout this course, I use an example, and my main protagonist is a guy named Johnny Swanson. And Johnny is an average American, which means he's an idiot. And of course, all of us are not, none of us are idiots at all, but you know who I'm talking about. Unfortunately, a lot of the average Americans I'm related to. They're part of my family. So Johnny is a resident of the state of Georgia. And so Johnny can be sued in Georgia because he lives here. So a Georgia court would have jurisdiction over Johnny. But what about a situation where Johnny is sued in another state apart from where he lives? So let's say that Johnny gets sued in Alabama. Under what circumstances does an Alabama court have jurisdiction over Johnny, who is a non-resident of that state? All states have what are called long-arm statutes, and what those long-arm statutes do is that they confer upon a state the ability to have jurisdiction over a person from out of state so long as the lawsuit involves an action that happened in the state where the person is sued. So we're going to examine that a little bit deeper in some examples in just a second. Another way that a court can decide whether there's jurisdiction over a person in the situation where we're dealing with a corporation is that a corporation is deemed to be a resident of the state where it's incorporated. Apologize for the train whistle. It comes by every day at this time. Corporations are, so they're citizens of the state where they're incorporated. They are citizens of a state where their principal place of business is located, and they are considered to be citizens of any state where they do business. So, for example, if Tebow Corporation is incorporated in the state of Georgia, it has its main offices in the state of Tennessee, and it does business throughout the southeastern states. Then, for purposes of jurisdiction, Tebow Corporation can be sued in Georgia, because that's where it's incorporated, Tennessee, where it has its principal place of business, or any of the southeastern states where it does business. And the way to think about this is that is it fair for a person to be sued in a state other than where they live? And this came up in a Supreme Court case called International Shoe. That was the name of a company. And the issue in that case was whether International Shoe could be sued in a state other than where they were incorporated or where they had their principal place of business. And the idea of minimum contacts and the long-arm statutes arose from this case. And basically the guidance that the Supreme Court gave in International Shoe was that as long as it doesn't offend our notions of traditional justice and fair play, then a non-resident can be sued in another state. So what does that look like on a long-arm statute? So let's take Johnny again. Let's say that Johnny works in Phoenix City, so he drives over to Alabama every day. And on the way to work one morning, he rear ends a school bus. So can Johnny be sued in Alabama for a case that is related to his collision in Alabama? And of course, the answer to that is yes, that makes sense. That does not offend any notions of fairness or justice, that a person can commit a wrongful act in another state and be sued there. So that makes sense. It becomes a little bit more murky, though, when we're talking about people being sued for reasons that don't really have anything to do with their connection to the state. So let's say that Johnny vacations every year in Panama City, and he also bought a car. Let's say, he sold a car to a resident of Florida. And the Florida resident wants to sue Johnny in the state of Florida. As long as the Florida person is suing Johnny for something that relates to their transaction of selling the car, they can do that in Florida. If they want to sue Johnny over something that happened on his, or let's say that Johnny sold the car to an Alabama resident, they could not sue Johnny in Florida because his contacts with Florida are just that he vacations there, and those are not related in any way to the reason Johnny's being sued. I hope I didn't make that too muddy. Let me take another example. Let's say that Johnny sees a Facebook post put up by a guy named Frank, who is in Oregon. And on Frank's Facebook, he has a picture of an antique car that Johnny covets. Now, Frank's post just shows a picture of the car. It doesn't offer it for sale, doesn't indicate that it's for sale, nothing of the sort. It's just a picture of a car. Well, Johnny calls a buddy of his who lives in Oregon, Ricky. And Ricky's a car dealer. And Johnny says, "Hey, Ricky, I've seen a car on this guy Frank's Facebook page, and I'd love to buy it. Do you think you could work that out for me?" So Ricky contacts Frank and asks if the car is for sale. Frank says it is, and Frank sells it to Ricky. Now remember, Ricky and Frank are both residents of Oregon. So that transaction is complete. Ricky then turns around and sells the car to Johnny. Ricky faxes the sales contract to Johnny in Georgia. Ricky delivers the car personally, drives it across the country, and delivers the car to Johnny's residence in Georgia. The car turns out to be a lemon, of course, because that's Johnny's luck. It's the kind of person he is, and he wants to sue for it. So can Johnny sue Frank and Ricky in Georgia because the car was a lemon? So we would have to look at each of those persons' contacts separately. In the case of Frank, Frank did not do any advertising of the car in Georgia. He did not have any contact with Johnny. Frank did nothing but sell his car to another Oregon resident. Ricky, however, did do business with Johnny across state lines. Ricky sent the sales contract to Georgia, and Ricky delivered the car into Georgia. So with respect to Ricky, we would say that, yeah, Ricky's minimum contacts with Georgia are related to the reason that he's being sued, and it would be fair that Ricky would be sued in Georgia for a car that he sold to a Georgia resident. Frank, on the other hand, would not have any contacts with Georgia such that he could expect to be sued because the car was a lemon. Let's say that Frank attends a ballroom dancing convention every summer with his wife in Georgia. That still would not be enough for Frank to be sued in Georgia because Frank, his activity in Georgia is not related to the reason that he would be sued, which would be the car being a lemon. So hopefully that will sort of illustrate for you a little bit better how a person might be sued in a state where they don't live. These days, when it comes to businesses, it's pretty hard for any business to claim that they don't do business in another state if they have an online presence, because obviously the internet, we can't direct which states the internet goes to. If we are selling something or offering a service and that sale is made or service is engaged based on any of the advertising or anything on a website, any kind of internet activity, it is almost always going to be found that that business is going to be subject to being sued in those states. And of course, obviously, as is with every case is different and will be decided on its own facts. But for businesses, you just need to be aware that it's most likely that if they're doing advertising or have an online presence in other states, that they're going to be able to be sued there. So that is jurisdiction over the person or the thing. Jurisdiction over subject matter means that the court where the lawsuit is brought has to have the power or the authority to hear that type of case. So in Georgia, for instance, we have probate courts as one of our basic court categories. And probate courts can only hear issues having to deal with wills or the estates of deceased persons, or issues with guardianships or conservatorships, and there's some other things probate courts can hear. But those are the subject matter jurisdiction of a probate court. So if I have a dispute over my deceased father's will, I can't bring that in another court because that court doesn't have subject matter jurisdiction over a will dispute. And we're going to look at the different categories of Georgia courts in just a second. Another distinction having to do with jurisdiction is original jurisdiction over appellate jurisdiction. What that means is that original jurisdiction, that is found in the courts where a case begins. Appellate jurisdiction means that once a case has been decided on a trial court level at that court of original jurisdiction, which court can that case now be appealed to? That court would be the one that has appellate jurisdiction, and I'm going to illustrate that for you in just a second. Let's take federal courts first. There is a chart that I have posted for you in the Chapter 1 and 2 module. It's the Week 1 module, and it is a chart of the federal court system, and it's going to help talk us through jurisdiction. If you can pull that up now, if you have that already printed out in front of you, go ahead and pull up the other handout that's titled the Georgia Courts handout, and go ahead and pull that up too, because we're going to talk about both of those. But if you look at the federal court system diagram, you'll see that the United States District Courts, that is where cases begin in the federal court system. Those are the trial courts. That is where you would put on evidence, you would present your witnesses, you would make your opening, closing arguments, and the judge or the jury would make a ruling or issue a verdict. The appellate jurisdiction for federal court system is found in the United States Circuit Courts of Appeal and the Supreme Court. And you can see through the diagram that the first stop after your trial in a district court, if you're going to appeal, is going to be the United States Circuit Court of Appeal. And then if you don't like your result there, you can appeal to the Supreme Court of the United States. So, if you'll look at, let's just look at the Georgia courts real quick as a comparison to that. The 7 courts that you see on the bottom 2 rows, Superior Court, Probate Court, State Court, Juvenile Court, Recorder's Court, Municipal Court, Magistrate Court. Those are all the different categories of courts that we have in Georgia. And each one has a specialized area of cases that they hear. So, for example, Magistrate Court and Municipal Court are local courts, or what you would know as small claims court. And they have jurisdiction over matters involving city ordinances or claims that are under a certain amount of money. Recorder's Court has jurisdiction over preliminary hearings and criminal matters and some traffic issues as well. Juvenile Court obviously has subject matter jurisdiction over matters involving anybody under 18, both criminal and or children who are found to be dependent, meaning that they can't live with their parents either temporarily or permanently. State Court and Superior Court are kind of the biggest trial courts or courts of original jurisdiction on our state level. Most of the cases that we have are brought in either one of those courts, and there's a significant amount of overlap between those courts. So most of the cases that can be brought in state court could also be brought in Superior Court and vice versa. And that is somewhat confusing for reasons that have to do with why our legislature decided to set up our courts that way. Probate Court, as I mentioned earlier, has jurisdiction over matters involving estates and guardianships. So those 7 courts at the bottom are courts of original jurisdiction. They are trial courts. If you go up one more level, you'll see the Georgia Court of Appeals. That's the intermediate stop. That is the court of appellate jurisdiction, and where most appeals from those bottom 7 courts would go. You will see there is also a line from the Superior Court that bypasses the Georgia Court of Appeals and goes straight to the Georgia Supreme Court. There are certain cases that our Constitution says go directly to the Supreme Court on appeal, and they bypass the Georgia Court of Appeals. The other courts would be appealed first to the Georgia Court of Appeals, and then if the person doesn't like the result there, then they would appeal to the Georgia Supreme Court. You will notice that Superior Court, one of the bottom 7, is a court of original jurisdiction, but it also is a court that has appellate jurisdiction in 2 instances. Magistrate, Municipal, and Recorder's Court, those bottom 3, those can all be appealed to Superior Court first, and then from the Court of Appeals into the Supreme Court. Probate Court, likewise, can appeal to Superior Court first, and then Court of Appeals and the Georgia Supreme Court. If that's not confusing enough for you, then there are some cases that if they make their way to the Georgia Supreme Court, they can be appealed to the federal court system. In other words, they can jump from the state court system over to the federal court system, to the circuit courts of appeal, and then to the Supreme Court. And those are usually cases that involve issues of federal law. So that is sort of just a general layout of the federal and state court system. There's a lot of overlap between them, as you can see, and we'll talk a little bit more in detail about that. So back to federal court jurisdiction for a second. Federal court jurisdiction generally, as far as subject matter jurisdiction, means that it needs to be involving a federal law of the United States. The federal district courts have original jurisdiction, have subject matter jurisdiction over anything that involves a federal law. So if I were going to sue, let's go back to Johnny. Johnny gets fired, which happens pretty often, and he believes he's been discriminated against under a federal law or in violation of a federal law. And so he would sue his employer in federal court because that involves a federal law. If there are disputes between citizens of different states, they could bring their dispute in federal court, so long as it's over a certain amount of money. I think currently it's $75,000. Then federal courts would be open to you. And then also to kind of muddy the waters, there are cases that could be brought in a state trial court or in a federal trial court. And then there are cases that start out in the state court system, but then could jump over to the federal court system, as I explained earlier. And there are cases that start out in the federal court system that could jump back over to a state court system in certain circumstances. It's not going to be crucial that you know all those ins and outs of that. It's just important that you understand the structure of the federal court system, the structure of a state court system. If you remember the idea that some cases can start out in either court and can jump from one to another, and that there's a significant amount of overlap in those. Your book gets into some good detail on that. I would definitely pay attention to that. I think there'll be some quiz questions having to do with where cases could be or need to be brought. We talked about the fact that cases could be brought in either one. There are some cases that can only be brought in certain courts, and I think we've already talked about some examples of those. What factors would go into the decision of deciding whether to enter your case in the state court system or the federal court system if you have a case where you could choose either one? What would sway your decision? Some factors might be the availability of different remedies. Sometimes the relief that you can get in federal court would be different than the relief you could get in a state court. Say the distance to the courthouse, how convenient it is for you. There are state courts, there are these trial courts in every county in the state of Georgia, whereas there are in Georgia only 3 district courts. So it might be more convenient for you to litigate in your home county than it would be to travel to an out-of-town district court in the federal court system. It might be the experience or reputation of the judges in that certain district versus county. And then, the reputation of certain courts for maybe giving larger verdicts or being more plaintiff-friendly or being more friendly to law enforcement or to criminal defendants. Just certain courts do develop reputations. So that might be a factor that would weigh in. We have talked about trial and appellate courts. Another distinction I'd like for you to know is that the trial courts, again, that's where you put on your evidence, you call your witnesses, you make your arguments, the judge makes rulings, the jury gives a verdict. That is all exclusive to a trial court. When you graduate or you move up the line to an appellate court, then the appellate court on appeal is not going to retry the case. You are not going to present any evidence to the appellate court that wasn't already presented. You're not making any closing or opening arguments. There's no jury to give a verdict, and you are not calling any witnesses. An appellate court is going to have a written record of everything that happened at the trial court level, and the job of the appellate court is to decide whether there was any errors in the application of the law to the case. So say that at trial, Johnny's on trial and for arson, and he has been convicted of arson several times before. And so the prosecution wants to introduce into evidence in Johnny's trial the fact that he's been convicted of arson all these other times. And Johnny's lawyer argues that that would be prejudicial. So when the state's lawyer tries to introduce that evidence, Johnny would then make an objection to the judge, and the judge would have to decide whether or not to allow the evidence to come in as to Johnny's prior arson convictions. And so the judge would have to base that decision based on the law, and there is law about whether or not you can mention prior instances in present trials, prior conduct of a defendant. And so the judge will make that decision, make that call. Yes, I'll allow it. No, I won't allow it. And so one of the issues on the appeal might be that Johnny's lawyer says it was error for the judge to allow that evidence in. So the appellate court is not going to talk about what the evidence was or decide whether Johnny did or didn't do anything. Their job is just to say that was error for the judge to do that, or it was not error for the judge to do that. Everything that happened at the trial court, there were no errors to be made, and so the decision of the trial court should stand. Real quick, for appellate courts, usually the state Supreme Court and the U.S. Supreme Court, you don't have an automatic right to appeal to those courts. You have to ask those courts for permission to appeal, and if they grant you permission, they'll hear the case. If they don't, then your case is done. The majority of the cases that get appealed to the United States Supreme Court, they do deny permission to appeal. So they really only hear a very select few cases. They make those decisions based on whether or not the decisions would be important to the country, or they issues of great impact or great import. Excuse me. Thank you. All right, let's follow a state court case through the litigation process quickly. Our common law state court system is an adversary system. That means that both sides have the opportunity to present evidence and to ask questions of the other person's witnesses. That's called cross-examination. There are rules of procedure that govern every step in litigation in a trial court. The first thing that happens is that there are pleadings filed. That is all the paperwork that gets filed officially in the case. To use a sports analogy, the kickoff to litigation is that one person files a complaint. The person who files the complaint is known as the plaintiff. The person against whom the complaint is filed is known as the defendant. In the criminal context, the state will always be the plaintiff, and the person accused of the crime will always be the defendant. Normally better to be a plaintiff than a defendant, but it happens. The plaintiff's complaint will be filed with the court. It will state what kind of case it is, what law is alleged to have been violated, and what the relief is that the plaintiff is seeking. The complaint will then be served on the defendant by the sheriff, and that is to give the defendant notice that a lawsuit has been filed against him. And then he will file an answer to the complaint, either admitting or denying the allegations of the complaint. The next step in the process will be discovery, and that is when the parties are allowed to seek information from the other. There are different forms of discovery. In civil law, you are allowed to send interrogatories to the other party, and that's a set of questions that the other person must answer in writing and under oath. You're authorized to send requests for production of documents, asking that certain documents be produced. So in a divorce case, I might send interrogatories asking the other party all of the places where they have financial assets, what property they contend is separate property, what are the reasons they contend that that's separate property, what are the reasons for the divorce, what are all the things wrong that they're claiming their spouse has done. If there's infidelity, the names and dates and details on all of the instances of infidelity. For document request, I would ask for checking account statements, credit card statements, telephone records, emails, that sort of thing. And then another form of discovery is a deposition. That is a sworn question and answer session that is taken down by a court reporter. And that is where the other party's attorney gets to ask the opposing party questions under oath. And the scope of the questioning is extremely broad. And so depositions are usually a very effective way to discover material that may be helpful to a case. Be aware that in your business careers, if your company is sued, then you are very likely to be, or not likely, but if the dispute involves something that you had a part in, then you're going to be a witness at least. You may have to sit for a deposition. You may have to help the company answer interrogatories. You might be part of the company's effort to collect the documents that have been requested to be produced. And you should always be very, very careful about anything that you put in writing in an email or any other document that may be in a corporation's file, because those documents down the road may be subject to a discovery request, and those might be produced to another side. So it's something to be very, very careful about. As you go through the litigation process, you'll eventually, if you have a jury trial, the jury will be picked. The trial will begin. Opening statements are made by the lawyers. The plaintiff always goes first and puts up their case first, so the plaintiff will call their witnesses, will produce any evidence that they have, and make argument with respect to that. Then it'll be the defendant's turn, and then at the close of evidence, each party will make a closing argument. And this is the part of the litigation process that you're probably most familiar with from TV and the movies, and Law and Order. At the end of the trial, if it is a jury trial, the jury will issue a verdict. If it is a bench trial, that means there's no jury involved. The judge will make a ruling. If the losing party does not like the ruling, then they will have the right to appeal up to the next level appellate court. And we talked again that the appellate court is going to review the trial court's decision to see if there are any errors made. The appellate court could either say there were no errors made, and so we affirm the trial court's decision. The appellate court could say we find that there were errors made, so we reverse the decision, and we're going to send it back to the trial court to be tried again. If the appellate court decides that there were errors and they reverse the decision, that doesn't mean that the person who lost at trial court wins all of a sudden. It just means that because there were errors and the decision is reversed, that the case has to go back to trial court and start all over again from the beginning. Courts are moving increasingly to online presence. We file a lot of the pleadings online these days. You can search courts' dockets and databases. A lot of what they have on file as public record, and it's searchable now. And so that is certainly a change in the ability of folks to gather information about other cases and other people. This lecture has gone on a while, and so I'm going to continue to finish as fast as I can without cheating you on the topic of alternative dispute resolution. As you know, or as you should know, court systems are crowded and clogged. It takes a long time to try a case at trial. There's no way that every case could make it all the way to trial and everybody to have a timely resolution of their case. There is not enough capacity within our court system to allow that. And so what happens naturally is that cases get settled, and we have put some other dispute resolution methods in place that help parties settle their cases without having to go to court. And there are many, many advantages to that. If you can settle your case without going all the way to trial, then you save time, you save money. It is much more efficient, and you're able to get a resolution and get closure to your issue much sooner than you would if you had to wait all the way until your trial comes up. This is particularly glaring in a time like right now, where at the time I'm filming this, we are still in a judicial state of emergency due to coronavirus, and the courts have been shut down for 3 months, and the word is they're going to be shut down for a fourth. So that's a third of the year that we are not moving any cases through the court system. And so alternative dispute resolution becomes even more attractive in those situations. One method is just pure negotiation. There's nothing that says that two lawyers can't call each other up or sit face to face in an office and negotiate a resolution to a situation. That happens often. If the parties and lawyers want to negotiate, but they feel like a middle person would be a good way to get this done, then often people will engage the services of a mediator. They'll go to mediation, and at mediation, the mediator is a neutral party. Parties go to separate rooms, and the mediator goes back and forth and tries to see if he or she can settle the case. It is particularly effective in divorce cases and family law cases, and in car wreck or personal injury cases. Mediation has a pretty good success rate in settling those cases. Another alternative to going to court is arbitration, and that is different from mediation in that whereas the mediator is neutral and doesn't make any decision, he or she just tries to help settle the case. The arbitrator has the authority to actually make a decision that is binding on the parties. And so it is, in some respects, like a mini trial. There would not be jurors, and the arbitrator would not be a judge, but it would be a person that the parties give the authority to make a decision about their case. You should know that in many business agreements and in many employment agreements, there is written into those an arbitration clause, which says that if the parties have a dispute over any issue in the employment agreement or in the contract, that they will first go to arbitration in lieu of going to court. And that is preferable for businesses in that it allows the businesses to kind of limit their exposure to the cost of litigation. They know that they're not going to go through this long, drawn-out discovery process and litigation motions and hearings and a trial. Instead they know that they're just going to go to this more limited arbitration instead. For employees or for consumers, sometimes that is not as good a thing because the employees may want the expanded features of going to court that are not available to them in arbitration. So just be very sure that if you read something in a contract or an employment agreement that has an arbitration clause, that you realize what that means. That is the end of the online lecture for Chapter 2. All right, good luck.